interesting. So the big strategic cases, obviously, for your organization. How do you go about choosing decision makers when cases are truly strategic to the business? Who leads the discussion on that? Is it the outside lawyers? Does the legal team within the organization have strong views as to who these people should be? Are they lawyers? Are they industry people? Tell us how it works on the inside.
Yeah, we are team players. So this means, first of all, in the litigation arbitration team, we consider ourselves as service providers, internal service providers. This means the business owners is our patent business. So they, for example, come to us. They say, we had negotiations with company X. We don't get any further. We don't come to a solution. We should now consider taking legal actions. And then we make a strategy. Usually at that point of time already we involve our external advisors. Depends on the case. At what point of time we involve externals. But usually we do make a strategy where we propose which forum to take, arbitration, litigation, and if you have a choice of various, for example, different state courts, different arbitration regimes, we make proposals. We make proposals about possible teams who we would recommend as external counsel, who we would recommend as arbitrator, for example. We make, of course, budget plans. We make our best guesses about likelihoods of risks, of successes. Yeah, and then in the end, we present this to the stakeholder, to the business owner, and he has to make a decision, usually together with us. And depending on the value, sometimes it's made on VP level, sometimes it's made on board level. But I think this is always, in the end, done as a team decision, so that we discuss it and come together to a decision.
Johan, I can see you nodding your head there. So is it a similar experience for you?
Absolutely, yes, it is. Yes.
And what about choosing the arbitrators? Do you have strong views as to who's right for particular
That's
cases?
a problem, I have to say, because I don't know, I don't have that knowledge, I think, to select an appropriate arbitrator. You have to work very intensively with arbitration all the time as external counsel, I believe, to have some kind of view, or a better view at least. But that's interesting that you ask this question, because I believe actually that the parties themselves should be relieved from this obligation to nominate an arbitrator. I think that the arbitral institutions are much better vested to appoint a single arbitrator or all three arbitrators. So that's my thought about that issue.
I know, Isabelle, what are your thoughts on that? And Kirsi also.
3 points, perhaps. One preliminary, but in my view important, is that arbitration is never, nor the beginning, and neither the beginning nor the end of the story. So companies, of course, very, very used to negotiations, and the first, and it's in its gene to negotiate for whatever conflict. And when it comes to mediation, it's a bit more difficult because it's still not in the gene at all, in spite of our efforts. But it's coming, because we consider it like an assisted negotiation. So apart from this view of coming to an agreement in the end, we go to arbitration. That said, I think that with arbitration, we can address not problems, but solutions that we cannot get through negotiation and mediation. So when it comes to very strategic points, generally legal points, which may be to get new industry positions, to get a new position towards an important partner, then generally there is no other solution, because obviously we cannot agree on that because the interests are totally opposed. So there we go to arbitration. And but it's even in that case is never the end. In the end, we always negotiate something, and that's the way to transform. And it happens more than once. An ex-opponent to a new partner, contrary to what is generally said that litigation and arbitration is war, so it's forgetting about any collaboration anymore with a partner. Well, that's not my experience at all. When you change your position towards a partner, then at a certain point he has to accept it, and it's generally its interest to accept it, and so he becomes a very good partner. So that's a point. The second point is the legal department involved in the nomination of arbitrators? Yes, not only involved, but they are the only one to decide on that. Well, at least in the way we are organized. We are organized as taking in charge all the conflicts problems and taking the responsibility of it, meaning that counsel are considered as a sort of prolongation of the legal department. And if there is a bad result for whatever reason, it's not a third-party responsibility. It's the legal department responsibility. And I think that's very important in the way. So that's the way it works. And I add even more, if I may say, for the big stakes, for the big problems, and for the sensitive problem. Of course, we informed and we have committees with the top management of the company. But let's say if the key decisions are taken through those dispositifs in common, but in fact they generally agree to what we propose. So that's a way to, to have things in hand. So yes, we do choose, because in most of the cases it's a very, in our view, strategic decision, the choice of the arbitrator. And of course, with the councils, we work as teams. That's obvious. That's the way to work, because both are very, very different roles. Whatever the expertise of the one and the others, the role of the one and the other are not the same. And when we understand that it's a team and what is the responsibility of each part of the team, then it's very, very efficient, according to my experience. So it may happen that we don't agree with the proposal of a council about the name of an arbitrator, not because it's not a good arbitrator, that's not the point. We totally trust generally our councils, but it's the name of the arbitrator is a characteristic of the way we want to go, especially when we are taking the lead, when we are claimant, and I'm thinking particularly to, let's say, drawing the case versus a local view towards an international one, for example. So that said, to follow your point, that's a very challenge point. Normally, the companies, the users, are very, their view is that the only way the only, let's say, power they may have into the arbitration is precisely the nomination of the arbitrator, and so they don't generally want to forget about that.
Well, perhaps, perhaps in that case, the question to you might be precisely why would you be willing?
I think, first of all, yes, the legal department at Electrolux, we are very much involved in the nomination of arbitrator. We are, but still. So we are faced with an arbitration, and we have to nominate an arbitrator. So what is our reasoning then? Well, we try to find a competent, experienced arbitrator, knowledgeable in the subject matter. And then we believe that we have found such an arbitrator. He's nominated. We discussed this, obviously, with the external counsel. And what happens next? Well, the other party will probably just nominate an arbitrator who has a reputation of never voting against the party who nominated him. So there immediately you'll have imbalance in the arbitral panel. And this is the reason why I propose that perhaps it is better to rely on the institutes instead and their competence to appoint the entire arbitral tribunal. And obviously, I don't know if the institutes themselves are happy to take on that task, but it's an idea which I invite everyone to have opinions about.
I know Clemens, tell us about your in your FRAND arbitrations.
Yes.
How would you feel about not having any involvement?
So
in
that is usually exactly what we try to avoid, actually. So the nomination of the arbitrator is, in my view, the most crucial thing in the entire arbitration. And what we usually do is that first of all we set a profile. What kind of skills we expect from our party-nominated arbitrator. So coming to FRAND arbitration again, for example, it is a very substantive question at the beginning whether you want more a commercial arbitrator or whether you want more an IP arbitrator. Do you want to make it a technical arbitration where you really look into individual patents? How valuable are they? Are they valid? Are they used? Are they essential? Or do you want to make it more like a commercial exercise that you basically look how much do maybe other companies pay for the same license? How much does the defendant pay for other companies' patents, to make it more kind of this commercial, this economic exercise? So that is something which we think about before when setting the profile of our potential arbitrator. In the second step, then we make a short list, which we circulate within the team running this project, and usually everybody has some objections against at least one, so that then usually we have the shortlist already reduced from 10 to 5. Then in the next step, in the third step, we contact these 5 whether they are available. This then often limits the list to 1 or to 2, and here we have our decision. Something which we also always keep in mind is who could be a potential chair of the tribunal. So it might also be sometimes something you want to consider if you think somebody's good qualified for your arbitration. So maybe you do not nominate them as your arbitrator, so that then you can later recommend him as a chair. So that is also something which we somehow have to keep in our mind. Yeah, but of course, if both sides cannot agree on the chairman, then the institution nominates the chairman. And as I said, that is usually what we try to avoid. And in my experience, that is also usually what the other side tries to avoid. So I've seen many cases where a lot of shortlists have been exchanged between the parties. There are different kind of rules how you can do that you do it blind or that you do it simultaneously, and so on. You all know these kind of games, yeah? And whenever we speak to the other side, we couldn't agree yet. Why don't we extend the period to nominate the chair for 4 weeks? I've never seen that either side has objected to this. So therefore, I think in very most of our cases we did agree in the end on the chairman.
May I add a word on that? It's a controversial question. I must admit that I have no final opinion on that. When I used to be the chair of the CCIEG, Corporate Counsel International Arbitration Group, we organized the first conference by the CCIEG, and it was just about that. It was choice of the arbitrator for a renewed legitimacy. And the discussion was really rather, hot. And so generally users were against the choice by the institution. The main argument for the choice by the institution and not by the parties is efficiency. And on the other side, we can see that in many times, not most of the time, the main job is already done by the institution rather than by the nomination of the sole arbitrator or through the nomination of the chair. So I would say that I would be in favor, because it's my perhaps idealistic view, of a choice by the institution. But I have to say that again, it's sometimes a strategic voice. So it's an important. I think it's an important. It's not decided. It's an important challenge. On the other side, there is the risk for the institution to become a kind of perhaps administration, and with fights of another kind, which we totally out of control of the parties, definitely. So it's, for me, I have no final view again.
Yeah, what about the services that institutes offer? There's been a recent announcement by the ICC, for example, that they will publish the names of arbitrators on their website, including information on whether they're party nominated or not, and whether the case is still pending. Would these kinds of services be of use to you? No?
No, I like confidentiality.
Mm-hmm. Okay.
It's same here.
Right. So much for offering services.
I mean, of course, whenever you choose an arbitrator, you try to get as much information as possible. And if there is information available, we would certainly look at that. It would be stupid to ignore it. But I am not sure how much influence this has on the decision in the end.
Okay.
Confidentiality is key. Yes.
Right.
So let's open it up to you, the audience. Who would like to ask a question? Please do identify yourself and your affiliation. And if you want to direct your question to one member in particular, please say so. Otherwise, we'll assume that you want to hear from everyone on the panel, except for me, of course. Who would like to ask something? Please, at the back.
Do we have this? Can you pass it on? Yes? Oops.
Thank you. Hello, Anna-Maria Tammen, Handelsnamen Helsinki. I have a question to Clemens, because you said often you'll extend for 4 weeks to get a chair nominated by both parties. Is it then your experience that you've gotten worse chairpersons if they've been appointed by the institution? So is it more of an illusion question, or is it actually worse in practice?
First of all, I've rarely experienced that even after the extension we have not agreed on a chairman, so therefore we have rarely had the situation that the institution then nominated the arbitrator. But if they do so, I've seen that both parties submit to the institution profiles, what he should be like, what he should not be like. And I would say the selection by the institutions we got so far were maybe not necessarily people on our shortlist, but they were acceptable people. So therefore, we can live with that. So it's something which works in the end.
And Marie, you can either just throw it to anyone, or you can wait and see if there's a hand in the air.
Sophie Lappalainen from the Arbitration Institute of Stockholm Chamber of Commerce. I have a question to the whole panel. And the institutes, we often get criticized that there are no new names coming to the pool of arbitrators and that the pool is really closed. And so the institutes try to work with that and try to get the new names into the smaller cases, and that the parties maybe are a little bit hesitant to appoint new names. So how do you think this problem of getting new names into the pool of arbitrators should be tackled? Because what I understand from your answers is that you have these known names with known experience that you are kind of comfortable with working with.
Please, Johan.
Well, thank you. I think just during lunchtime, we were discussing here this issue, and maybe an idea sprung up there that maybe it could be made through the appointment of secretaries to the arbitral tribunal. Maybe the institutes could have lists then of young arbitrators who can appear as secretaries, if appropriate, and through that process, maybe then they can gain the experience to finally gain confidence to be nominated, whether by the institute or by the parties. That's an idea, at least.
Isabelle?
But obviously, my answer to your question would be to allow for the institutes themselves then to nominate the arbitrators, and then you can also improve gender equality.
Going back to the nomination of the arbitrator, I think that it's a very different question whether to appoint the co-arbitrators and the chair. Mm-hmm. And I'm still more or less with the idea that nominating the co-arbitrators, it's good that it's been done by the parties. But for the chair, I'm a totally different opinion, because generally it's a waste of time. And I think that it is that the service provided by the institution in that case is of great added value in the relevance of its choice of the chair. So going back to the question of young or new arbitrator, I think that it's better to rely on the institution rather than on the users, because they are very conservative in that point. And we can understand that, because there is a question of responsibility behind, and you cannot ignore that. So, in most of the cases, people will have to in case it goes bad, to explain, say, well, I've taken all the securities in a way that I could. So I think that there is a very important role of the institution to open the panel of the arbitrators, and I think that exactly what they do. And especially from the inside, since I'm from some months a member of the court in the ICC, I can only see that it's absolutely the politic of the ICC, and it's good. Because, and especially in the case where we nominate a sole arbitrator. I just wanted to add that, and that's a new thing, more or less for 4 or 5 years only, that my recommendation is to include in the arbitration clause, instead of the usual, we will go to 3 arbitrators, and I say to 1 or 3 arbitrators, go back to the standard clause of the ICC, because you cannot say from the beginning that you will be happy with 1, but you cannot say that you won't be happy with 1. So it's good when the dispute has arisen that a discussion on that, even short, but with the other party, be initiated, and that we can go for 1 arbitrator only instead of 3.
I wonder, Heidi, if you want to say a few words about the approach of our home arbitration institute today. Even this morning we were sitting as a board making important decisions as to who to nominate in cases. But Heidi, why don't you say something about the philosophy of the Finland Arbitration Institute and some of our recent experiences?
Yes, thank you, Sophie. I think it's clear that we also in Finland and abroad, we have the usual suspects, the very good ones that we already know and who have performed very well. And then of course we get feedback from the parties after the cases have ended, so we always ask feedback. So that's obviously very important for us. But what we try to do is of course widen the pool of arbitrators, and one way of doing it is also in smaller cases to allow younger arbitration practitioners that already have good experience in arbitration their first chance. You must have the first time to be an arbitrator. And I think our experiences, my colleagues here may continue and say their opinions, but I think our experiences are very good. Normally the ones doing it the first time, they do it very well because they put all the effort in doing the work perfectly. So I think we have very good experiences on widening the pool of arbitrators as well.
Clemens, please.
Yes, I have also a comment to make regarding young arbitrators. So, first of all, I am very much in favor of young arbitrators for the simple reason that they usually get very engaged in the case and do a very good job because, of course, they're at the start of their career and they want to make advertisement for themselves and to be renominated. Other side, on the other hand, we see some, let me call them heavyweights, which are kind of permanently nominated, who have also made frustrating experiences with these heavyweights because, first of all, they accept too many cases. So we have seen cases where they were badly prepared. Most of the work was done by some junior associates and so on. So then then in the end you don't get what is on the label. So that is the downside of maybe some of these heavyweights. I don't want to put them all in one basket, but at least of some. But what you as an internal lawyer always must know, picking a young arbitrator is a risk. And it's especially a risk because if something goes wrong, and then you have to justify your decision internally, then you tell your board, it was a young person with no experience, with no background, or let's say with no reputation, but I thought she would, or he, or whatever, would do a good job. Well, unfortunately, I was wrong. Then I'm in problems. So therefore, it is a risky decision, and if I take it, at least I should usually make sure to back up the decision, so that I go to our general counsel and explain why already before we have the award, why I want to nominate that particular one, and what are the reasons and what are the risks, so that in the end, that's another issue, but risk management is in-house always a very, very risk management, especially expectation management, so that in the end everybody knew what was the risk, what were the options, and then that in the end people are not surprised if something goes wrong, and it must not even be the fault of that young arbitrator. I mean, it can always happen that you lose a case, statistically maybe 50%, yeah? So therefore that can happen, but you have to manage the expectations.
Kirsi, any sort of observations or suggestions from you as a young arbitrator?
I can say that I'm more than happy to convey this message tomorrow to the Co-Chair Circle second global conference that we will be having in Helsinki. It's of course good to hear that at least in theory you're open to the idea of having young arbitrators.
Yes, but in fact it happens rarely. Because it's very rare that we agree on the name of a sole arbitrator. So it goes back to the institution to nominate it.
Yeah. So it's all on the institution. There's a question at the end there.
Yeah, Andrea Carlevaris from the ICC International Court of Arbitration, Paris. I think Johan's remark is very interesting because what we observe is actually an opposite trend, which is parties trying to keep control of the process, even when it comes to appointing the chair or the sole arbitrator, for example, giving this power to the co-arbitrators, or trying to have a direct agreement about the chair or the sole arbitrator. From an institutional point of view, I can say, well, first of all, we are happy to do whatever the parties ask us to do, which means they may agree to have us appoint everyone or propose lists. Whatever agreement, of course, we are happy to follow. I would say that appointing arbitrators in all cases would be really a challenge for the institutions. We already see this now because on the basis of the ICC 2012 rules, we have more power of direct appointment, for example, when there is a state entity involved, and it is a challenge to find good candidates who are available and not conflicted. I would be reluctant to accept the responsibility of doing this for the 1,300 arbitrators we appoint or confirm in the cases every year. And the final point is, I think party appointment is also a way to open up the pool of potential candidates. I think giving this task only to the institutions would risk limiting the pool in the long run, because of course we would appoint people we have experience with, in most cases, especially in large cases, people we've seen acting as arbitrator. The way you get to know new and good arbitrators is sometimes precisely by party appointment, because we are talking about young arbitrators, but I think there is a need to open up the pool of potential candidates also for high-profile cases. There are very good lawyers or non-lawyers, potential arbitrators, and we always think about the same few names. I think it's up to the parties to appoint whom they trust. And finally, a very quick point on the publication of names, just to clarify. I think this is a very bold and also controversial measure that the ICC Court took in deciding to publish names of arbitrators. Just to clarify, it is not about giving information as to who appointed whom. It's just the composition of arbitral tribunals without revealing any information about the parties who appointed them.
Thank you for that. Can I ask you to very carefully throw the roving mic about 4 rows back? Thank you.
Hi, I'm Anina Lipkin for Baker McKenzie in Stockholm. And we've been talking about opening up the markets and thinking outside of the box. And now we're talking about the future of arbitration. And I wanted to ask a question especially to the in-house counsels and especially to Isabelle Hautot regarding a digital platform called eJust, which is, as I understand it, open for use in France and Switzerland. which is a totally digitalized platform. The arbitrators are appointed by the e-Just Secretariat, and a decision is supposed to be given within a month. It's considered to be very cost efficient. Is this something that you as an in-house counsel could maybe consider? And is this something that we will be seeing more in the future? And if so, will this affect how institutions today work?
Well, certainly we can consider it, but so far, in my experience, it's not totally adapted to our needs. Because again, it's, you know, in the end, the arbitration are not common routine, far from that. So when we go to arbitration, it's generally a complex case, for whatever reason. So it's not a question of fast track, of you know, no hearing and everything digitalized. That's not at the level of our expectation at all. We, in our experience, and that's true for complex litigation as well, before the state tribunals, the pleadings, the oral statements are key. You know, it's not only the capacity of the representatives of the company to synthesize the problem, to go straight to the real problems, and not to the, you know, that's key for winning a case, for shaping it, and for making it efficient, for making the proceeding themselves efficient. So our key word is not time, is not even cost, is efficiency. Because all is proportionate to the stakes, but not only in amounts. You know, the stakes may be not so big in amounts, but very important for the company and generally for the other company as well. So it's really keywords efficiency. So it may well be that in some cases, though fast track, digitalized are very interesting, but it's not something that we commonly use, because those cases are not treated, they're generally negotiated.
So we have a question in the middle over here, so it's quite a big pass. You might need to do it in 2 stages. Let's see. There we go. Excellent teamwork.
Thank you, Sophie. Jose Rosell, arbitrator in Copenhagen. I wanted to share with you a good experience. Particularly when I was acting more as a counsel, is when it was impossible to reach an agreement on the name of the chairperson. Then both parties reaching an agreement as which should be the process of the selection of the chairperson in case we fail to agree on a name. And we have been picking up several arbitration institutions and asking these institutions which of these institutions would be prepared to give a short list of 3 names or 5 names. In this way, I think we solve, as we discussed with Johan Ramberg during lunchtime, right? To solve this dilemma is who is really or who should be in the control of the nomination of the arbitrators. I think in this case you have an interaction between the institution and the parties. Both will going to play a role. You give the opportunity to the institution to really give 3 names objectively, and then counsel say yes, we agree. And in case there is a disagreement on the name of these 3 selected potential chairpersons, then we send back the ball to the institution. The institution comes back with a new list of 1, 2, or 3, depending on what we can agree. So every time we have been using this system, it has been extremely efficient because both parties and the institution played the appropriate role.
Thank you.
I think there was another question over there.
Stanley?
There we are.
Oops.
Oh.
Thank you. I'm sorry for that. I have a very quick question, because when you appoint, obviously, an arbitrator, you want to appoint an arbitrator, either the third or the co-arbitrators. What is your position regarding the cultural approach? Because that's the background of the arbitration. How do you feel and how do you make a choice do you take into consideration the cultural issue, where the arbitrator is coming from, how he's been trained, what sort of position he takes in the past? I would like to know your position in this regard.
Yeah. Well, absolutely. That plays certainly a big role. I mean, it just depends on, for example, which procedural rules you have. But also, just to give an example, if we are plaintiff, if we are looking for high damages, on our profile list, there might somewhere be the word American. Yeah, on the other hand, if you are a defendant, if you want to avoid high damages, if you want to, if at all, a very low amount, you might shortlist the German one. So, yes, but I mean, of course, these, let's say, these people who are working on an international arbitration since many years, they have opened up a little bit. That this is still at least a prejudice, yeah, that Americans are more prepared to grant some billions than a German arbitrator would be.
It's just in that connection as well. In my experience, it's quite interesting how the publication of awards in investor-state cases, where obviously one really can see what the appetite and attitudes to certain decision makers are on things like damages, has actually started to sort of creep in to commercial arbitration. So using that as a resource to due diligence particular decision makers. I don't know whether this is a good thing or a bad thing actually in the end, but
both.
My experience.
It's good and bad. It's good because we need to have information, and everybody, I think, need to have the more information as possible. On the other way, we absolutely want to keep confidential. So sometimes difficult, you know, even if you take out the names, it's the confidentiality is a problem. So. Both, I would say.
So how can we balance that then? The strong desire to retain confidentiality in many of these important strategic cases, but also that, you know, the recognizing that there is a good deal of value and benefit in understanding how individual men and women think about certain issues. Can this be reconciled at
yes,
all?
I think so. But it's a hard work on the award themselves, and to extract perhaps the relevant parts in order that the
essential reasoning.
Yes, but we need some part of the facts in order to understand the decision. So that's where the crucial point is. That said,
what do you think?
If I speak, for example, again about friend arbitration, all the relevant awards in this field, which are not so many so far, I said the ECJ case law is not even 1 year old. But still, all the relevant awards we will probably see through document production or through other sources. And so therefore, I think usually the players in this particular industry have a pretty good knowledge of the awards which are around.
On the other side, confidentiality is crucial during the proceedings. It may well happen that once the award has been rendered, the problem becomes totally different because it belongs to the past. You know, so the issue is not so crucial anymore.
Yeah, and I mentioned that a lot of our ongoing arbitrations, but also closed arbitrations are publicly known, because if you are a publicly listed company, you have obligations to make 20F statements, annual statements, whatever, and there you have to disclose at least some of the information. And this is enough information for other companies if you are in negotiations to ask, for example. And yeah, again, when I speak about friend, this means the 5 letters include at the end the ND, which means non-discriminatory. So this means I cannot discriminatory any potential licensee over any other one, meaning asking for higher royalties, which means that I have to produce all my license agreements to show them what others are paying for the same or similar license agreements, and so therefore there is a lot of transparency and a lot of documents is produced, and yeah, the parties will get aware of these.
It certainly seems like there's a certain inevitability to the opening up, the further opening up of the arbitral process in that sense. You know, it's partly social media, it's partly the use of big press campaigns, but it's also because many of these cases are touching on public interests, aren't they? On things that involve regulators, in very tightly controlled markets. sort of brings us into the future of arbitration. Where do we see it? Kirsi, what would you like to ask the panel about that?
Well, I think it might be time to vest our panelists with some superpowers. I know that in the mind of external counsel, in-house counsel may already sometimes possess superpowers, but I was wondering, going forward and thinking about the future of arbitration, I have a question that's been inspired by the Queen Mary survey, and you now have the opportunity to wave the magic wand and make one improvement in international arbitration. What would it be?
Well, one thing I was thinking about, I'm not sure whether it works or whether any one of you here in the audience has experience or has thoughts on that, but one thing I was thinking about, whenever you see this Justitia statutes, you see her with blind eyes, with covered eyes. So this means that actually a judge should decide without looking at the parties. So therefore I was wondering, can you make a completely anonymous arbitration so that the name of the parties are completely blackened, that the arbitrators have no idea who is the plaintiff, who is the defendant, and how might that influence the decisions? That is something I would really like at least to try once. I know it's complicated with all these documents you have to produce so that nobody can follow back where they come from, but that is something I would like to try.
Well, that's at least a true innovation. Isabelle, Johan, any thoughts on this?
Yes, I would, and I believe we'll touch upon this subject later, but I would like to see perhaps mediation being more weaved into the arbitral proceedings. I think that all of us have experienced that once the dispute has reached a certain maturity, it's easier actually to settle. And one idea would be to, when the arbitral proceedings have reached this level of maturity, the chairman has sent out a summary of the parties' positions and so forth, that the arbitrator could ask the parties then, would you like to mediate? And then refer the matter to a mediator. Because it is a little bit complex, I believe, for us to put mediation clauses into our agreements today, because we run the risk, at least as we perceive it, to have two parallel dispute resolution mechanisms, which complicates matters and possibly delays matters. So maybe my idea would be to weave in mediation into the arbitral proceedings.
And in the rules in themselves?
I'm sorry?
In the rules in themselves?
No, not that the arbitrator should mediate. I don't think the arbitrator should mediate, because then they run the risk of expressing views of where the parties stand, and maybe the award would be challenged. So I would instead like to see that the chairman refers the matter to an external mediator.
So an external mediator?
I'm sorry?
An external mediator,
yes.
Okay.
Isabelle, what's your superpower?
I should like to react to this position. On the one side, only the parties know when it's time for them to mediate. On the other side, during the arbitration, when one wants to mediate, the other doesn't. So that would be good in that sense, that arbitrators keep in mind that at a certain point, the fact that they asked the party to mediate may be efficient, just to, as an impulse to the reluctant party to perhaps to go forward. That's a point. On the other side, the expression by the tribunal of its preliminary opinion. I've experienced that. I know that it comes from a more or less a German practice, which may be very good in a way, and I understand that the idea is, again, to push the parties towards negotiation or mediation or whatever, to a settlement. But my experience for a very big arbitration for Orange, a very old one, was that it was disastrous for the proceedings, because it acted as it was in fact a sort of préjugé. And that the arbitrator then absolutely refused to change their mind. When they have, said their preliminary opinion when it was really the beginning of the case. So it was very bad in the end, and it was a total failure, this arbitration. So I'm mixed feelings. I think that, again, if companies are in an arbitration, they know why they are there. They have made every attempt to reach an agreement before, and they expect for an award. Perhaps it's a bit an exaggeration, sorry, but I am used to say that negotiation, mediation is a way to solve a conflict. Arbitration is not. Arbitration is a way to get an award, an enforceable award, which is very different. And that's why, even after an award, we generally come to negotiation, because not everything has been resolved, because if not, the arbitration would have a duration of 10 years. And that's impossible. That's makes no sense. So that said, to answer your question, if I had superpower, again, it's my ancienne. I would like that every party to the arbitration be focused on efficiency.
Mm-hmm. So efficiency is key. And thinking about efficiency, I was also wondering what kind of innovations we as law firms should do when we provide services to you. So I guess I have a threefold question. A, do you think that we should innovate in the way that we provide services to you in terms of arbitration? And B, do you find that we already do that? Have you got any examples? And C, if you do find that we've been innovative, do you think that the innovations serve you as clients, or rather us as service providers? Nobody wants to say in front of these.
No, I can start. I think that primarily the first service that an institution renders to users is the rules first. And the rules, the more clear and simple the rules are, the more efficient they are. That said, since things have become very complicated, there is the other trend to make everything transparent. I mean, accessible to everybody. And when the ICC came to the revision of its rule in 2012, it was this double challenge: to make things accessible, therefore written, when in fact the most important things are never written because they are such implied. As for example, that an arbitrator has to be impartial. It was not written because it's obvious, because if not impartial, you're not an arbitrator. Now, all that has to be written, considering the diversity of the parties and the development of the arbitration. And on the other side, if you explain too many things, you come to the goal contrary to what you expect, meaning that it becomes even more complex instead of accessible to everybody and not only to specialists. So that's a difficult balance, and that's what the ICC tried to reach, and I think they've made their best to reach that goal in 2012. That's for the rules. Again, each case is different, so the rules are to be kept simple in order to be adapted to each case. On the other side, there is this growing power of nomination and of decision when an arbitrator is challenged. That's a very important point. I think that the role of the institution is crucial, and that it's relatively new, at least in the fact that it's now a very important power, and their reputation is at stake. And I think that in the near coming years, that shall probably be a factor for distinguishing between the various institutions. This, a new kind of reputation and reliability.
What about Clemens and Johan? Do you think that law firms should be more innovative in how they provide services to you? going forward, looking into the future?
Law firms?
Yes.
Well, I think they're doing a
External
good
counsel.
job. Yeah, no, I think the ones that we use, they are doing.
I guess everyone in the audience is quite pleased at the moment.
I think we are receiving very good services from law firms, and if I saw anything to improve, I would have already asked for that, and then usually we get it. So therefore, in that regard, I can say that we are quite satisfied.
Right. So we have about 15 minutes left for our panel. Who in the audience would like to suggest either some sort of prediction for the future or a superpower of their own? What can we do to make this experience better? Who would like to venture something? Please, at the back, the middle. It's Chris Parker.
It is Chris Parker from London. This is not my idea, I shall say at the start. This is something the CPR in the US have been doing, and it goes back to our discussion earlier about whether parties or institutions should appoint. And they have what they call the screening process, where the parties appoint, but only tell the institution. And the idea is the arbitrators do not know who appoints them. Now, there's possibly a practical issue there that sometimes arbitrators will guess if they only know one counsel and not the other. But if we had a superpower that could say that could really happen, do people think that would be a good idea?
Well, that's very interesting.
Yes.
We've got some nodding of heads on this side of the panel. Johan, what do you think of that?
No, I think it sounds like half going half the way that I would like to see it, but it's a good thing. Should be tried out. And let me also express that I don't want to, this appointment by the Institute to be an absolute rule. Obviously, it's up to the parties to decide otherwise in the arbitral agreement. It's important, I believe, to say that. Yeah.
May I go back to the superpower second?
Absolutely.
It's at a totally different level that arbitration become truly international. And my experience is that it's not the case in a way that local law has become a key point in the contracts and in the arbitration, therefore, where it's in the end not at all the crucial point when we consider things practically. So there is a lot of fighting about that, and then a lot of energy spent about that, even on the level of the control, let's say, of the awards, and it's a pity. I really, let's say, hope that at last some truly international commercial law emerges. It exists, but people hardly know it and hardly use it, and that's for me really strange. And that's a path backward as compared to what was happening when I used to be a counsel in international arbitration.
Please.
Thank you. Birgit Sambert-Glasner from Geneva, Switzerland. I have two proposals. The first one is already used by some arbitrators, is to mediate the terms of reference. Because what we see in arbitration is finally that the parties sometimes are not part of this discussion, but only the lawyers. And it would be very interesting for the parties to understand that if we are having 18 witnesses to be heard, it's going to take a lot of time, energy, and so on and so forth. So involving the parties in the process, discussion about the process, is certainly something where parties inside counsel and so on are going to be much more involved on the result of the proceedings. So this is the first one. And the second one is what we're doing in Switzerland already is, and I'm following the path you discovered a bit before, which means often when people are coming into the Swiss chambers of commerce in order to get an arbitration, the Chamber of Commerce would propose whether or not they would like to have at the same time a parallel proceeding, a mediation proceeding, and run them, the two of them at the same time, of course not with the same neutral. And having been part of a couple of those proceedings, what we happen to see is, even though parties at the very start would like to have a word, as Isabelle would say, they realize that maybe their interest is not to have a word, but to have a dispute resolved. And finally, I mean, at least in the processes where I was part to, during the time the arbitrations were still working on competence issues, the cases were resolved on a mediation basis.
Interesting. Any reflections from the tribunal on that?
About witnesses, may I refer you to a song of Leonard Cohen saying, "I can't forget, I cannot forget, but I don't remember what." It's the title of one of his songs.
Yeah, also, let me please shortly comment on both. Yeah, I think first of all it depends very much on the company. So I think there are some smaller, medium-sized companies which just don't have the manpower, the capacity, the in-house capacities to be closely involved. They basically send the file to their attorney and then 2 years later receive the award. I think bigger companies, I know companies which have litigation teams of 50 people or so, and these companies are certainly very, very closely involved. So I personally think that in our arbitrations I'm very closely involved and that we participate in all decisions, in all the housekeeping decisions, but all the procedural decisions, what to produce, how many witnesses to hear, and so on. The entire case management, that is something we are closely involved, because for both sides there are chances, there are risks, there are costs involved, there is time involved, but yeah, so that is something everybody has to keep in mind, and I am responsible to run my case within my budget, so therefore I have a very natural interest in participating here. Secondly, mediation. Some years ago I was of the opinion that mediation is something for very emotional cases to bring people down, so especially for neighbors in a big debate about their fence, or about divorced couples in debates about the cufflinks from the kitchen or whatever. But this has changed. I have now really had a couple of experiences with all different kinds of mediations. First of all, I would say that reasonable parties always talk to each other, and I have not had a single case of arbitration, of litigation, where I don't frequently speak to my counterpart on the other side, and we do settle a lot of cases for both companies. This means that you have costs, that you have legal uncertainty, that you bind internal, external capacities. So therefore, we always speak with each other. Mediation, I have seen very good results. There are also state courts now, for example in Munich, which offer a new mediation procedure which has been applied very successfully. I think mediation makes sense if both sides have a real wish to settle a case, to come to a conclusion, and usually if the distance between them is not too big. Let's say one asks for 100, the other side offers 0.001, then there's absolutely no reason to go to mediation. But let's say if it's more like one offers 25, the other ones ask for 30, then and both just lead the last push to overcome this remaining difference, then these are certainly cases where mediation makes a lot of sense, and yeah, and this can also help internal decision makers to get some comfort or to get some justification for their decisions. So in that regard, I slowly but certainly turned to become a fan of mediation.
That's good news for the next panel, I suppose.
Nusha, are you going to?
Yes, Nusha Basiri. In looking into the future, what I would like to see, in fact, is that arbitration rules move away from the requirement of, when they are appointing an arbitrator, from the requirement that that arbitrator should not be of the same nationality than the party. I find it, to be honest, a bit archaic to think in ways that an arbitrator would be partisan to a party because it has the same nationality. I can see it when we talk about investment arbitration and where a state is involved and I have the same nationality as the state. But I would like to see, I would wish that arbitration practitioners by now are actually more open-minded and internationally thinking, and would not be immediately partial in favor. I'm a German national in favor, I would be in favor of Siemens. No, I don't. To be honest, and in my own practice, I have not seen, and we have in the last 15 years, have not appointed an arbitrator who would be from the same nationality as the party itself. So I find that the arbitration rules, and it's interesting that all institutional rules have this provision, that if the institution appoints an arbitrator, they should make sure that it is that arbitrator is not the nationality of one of the parties. And I would be interested to know if other people share this view as well, that we are actually acting in a real international environment, and that nationality in commercial arbitration should actually not be an issue anymore.
It's a really interesting question. What does our panel think of that?
If I may start, in my view, the nationality of the arbitrator does not so much matter, at least not with regard to connection to one of the parties. And you see, for big companies, it's so difficult to give them a nationality. So here we are in Finland, so I'm very happy to say that Nokia is a Finnish company. But is that true? We just acquired Alcatel-Lucent, which is now 50% of our company, which is French-American. So are we now a French company? Are we American? We make, I think, 2/3 of our turnover was in Asia. So are we an Asian company? We have 2/3 of our employees in Asia. And most people of our litigation team are based in the US. So if you look at the litigation team, are we a US company? So therefore, I think it is pretty difficult to stick a national label on a company, on a multinational company. And as you said, arbitrators, they might have a whatever Swiss passport, but live since 10 years in London and are married to whatever, yeah? So therefore, I think that nationality does not really matter. I think that, in my view, is not the decisive point, and I understand why these rules still exist in many arbitration rules, but for me it's not decisive.
Yes, it's true, I agree. But that said, the nationality is an appearance of neutrality. And we have to face the reality that still in certain countries, well, when you have somebody with the same nationality, it means something. I always remember Professor Berthold Goldman, who was always nominated as co-arbitrator when obviously he should have been chair. And that was, he was involved in French cases and nominated by French companies. And so he was not accepted or even proposed as chair, which was stupid considering the level of the man, and that was stupid. But again, I think all in all, it's an appearance, which has some value.
Yeah, I think that it shouldn't matter, obviously, but maybe it does. So, to some, and therefore I think that I'm fine that rule exists, actually. So.
One of the real topics of the last year or 18 months when we think about the future is what is the future of global trade going to look like? Are we going to see increasingly these sort of huge multilateral treaties, and in particular, are they going to provide for arbitration anymore? Or are they going to provide for something that looks far more like a permanent court, more of the traditional, perhaps political dispute resolution mechanisms? Now, I know that both of you have had some experiences within investor state, at least so far as public sources tell us. I mean, let's imagine a world in 5 years' time where a TTIP has come into force and indeed it doesn't provide for arbitration anymore. Do you think this will have a significant influence on the decisions of multinationals as to where to invest, as the conditions on which they're going to invest? You know, as lawyers, we are at the moment obsessing about what all of this will mean, but in practical terms, will it have a major impact or not?
Well, first, it's a very hot topic, and we are not at that point since the TTIP is not signed, and it's, you know, and well, very hot topic. And all the legal community is absolutely against the proposal of the Commission on that side, because in the end it comes to make all those disputes settled by tribunals, even judges, and in the end who will be, in a way or another, judges and parties at the same time, which is in itself unacceptable. On the other side, it's incredible that suddenly this system appears unacceptable by those same states who have proposed and signed it, because all the system of the Washington Convention is an invention of the states and a creation of the states, not of the companies. So it's not a private story, it's a totally public story. The real explanation is that now the Western countries, especially at that time the European ones, are reluctant to see the rules applied to them when they were perfectly comfortable to those rules applied to the other countries. So that's another story. And it's strange. And it would be, in our view, all the legal community, stupid to forget about all that knowledge which has been accumulated. There certainly must be some amelioration. How would you say amelioration?
Improvement.
Okay. Yes. But suddenly to throw all the system away, to go back to a state system is, rather strange. But at that stage, nothing has been accepted. So I think it would be premature to have ideas on what would be the outcome.
But the issue is clearly important. I mean, you
yes.
have very strong views.
Very important.
On
very
that.
important. Yes, we constantly. I'm working with the French organization which represents the French companies on that, and I'm constantly in relations to them because they need specialized advice on, because obviously it deals with international law, international arbitration, international law. So it's not there, they are not used to that. So it's it's a tricky question.
Clemens, any views from you?
Well, yeah, from my German perspective, at least, TTIP at the moment is a very, very emotional subject, and I think this is very much run by consumer environmental associations, especially Greenpeace, for example, who are giving German consumers the impression that soon they have kind of gene-manipulated food in the shelves in the supermarket, and this is all decided by secret, behind closed-door arbitrations, and that is at the moment, for many people, a no-go. But I am pretty sure that this will calm down very soon as we have the next topic on the agenda. And the entire business is very much in favor of this. And the government is very much in favor. I mean, such free trade agreements usually mean growth, mean jobs, mean wealth on both sides of the Atlantic, which in the end will succeed. And so therefore I'm pretty sure that we will get this agreement soon with arbitration clauses in it.
Thank you for that. Well, we have run out of time, I'm afraid. So perhaps you'll join with me in thanking our 3 panel members today, and also our rapporteur, Kirsi, whose job it will be in the coming weeks and months to provide a bit of a summary of today's discussion. It was such an interesting discussion. Thank you so much for sharing your experiences with us. Thank you to the audience as well.
Thanks to you.